You're tuned in to Agriculture Today, and we start our Wednesday show talking with K-State and Washburn law professor Roger McEowen on a case that involves trespass, nuisance, and right to farm laws. Roger, thanks for joining us today.
Thanks for having me, Shelby.
Roger, can you give us some background on this case that involves these different issues?
Well, this is a big case, perhaps the most egregious nuisance case that I've ever seen in Kansas, certainly the most egregious one that's hit the Kansas Supreme Court now. And it's out in north-central Kansas, northwest Kansas, kind of west-central, near the Nebraska line. And what you had here was an individual that owned multiple farming operations and put in about 2 miles of pipeline in the road ditch right-of-way next to a public road to transport the liquefied hog waste from this confinement hog operation they put in. And he's got a massive amount of manure that they produce, and he put those lines in to transport that liquefied hog waste to spread on his crop fields down the road a ways so that he could hook into his pivot irrigation arms. And so what he did was install 3 underground pipes, 2 that ran water to his hog operation and 1 that would carry the manure back, without the consent of the adjacent landowners, who were the plaintiffs in this case. And he also didn't follow applicable county permitting processes, and his daughter-in-law later filled out a permit application and paid the fee for putting the pipes in, but neither the county clerk nor the road and bridge supervisor ever signed the permit application. And he also created an impression with the county commissioners that he had the permission of the landowners adjacent to the roadway where he was going to install those pipes, but he didn't. And the county attorney came and told the commissioners that the adjacent landowners had to consent before the application could be approved because they actually owned the ditch right-of-way, and you have to have their permission to use their property. And that's what the county attorney properly advised the county commissioners of. But the fact remained, Shelby, that the commission never granted approval for him to install the pipes, and the county attorney then called the sheriff, who temporarily stopped the installation of those pipes, but he went ahead and ignored that. He completed the installation, and the sheriff then contacted the Kansas Department of Health and Environment. But KDHE said, well, wait a minute, this isn't our job. They regulate the disposal of hog waste, but they passed on this particular issue with respect to the pipes. Their issue is, how is it being applied? And does that conform with state regulation? And they said they weren't there yet, so they passed on the issue. But he consistently maintained that he didn't need permission to install the pipes in the road ditch right-of-way, and he went ahead and tried to lobby the county commissioners as well as the Kansas legislature for the express authority to put those pipelines in. He wasn't successful at that, but he tried. But those pipes went for a mile long along the plaintiff's road frontages, and the liquefied manure, then he did actually get it done, and it sprayed from a pivot irrigation system by virtue of an end gun on the pivot near a home of one of the plaintiffs who were also farmers, and that created quite a problem for them, and they sued for trespass and nuisance.
And this went through many different levels of court, starting at the trial court, and what came from there?
Well, he lost at the trial court level, and the trial court level said that what you did was you created a nuisance. You can't use the right to farm law because you were creating a trespass at the time because you didn't get permission to use those road ditch right-of-ways, and the landowners own the road ditch right-of-way. So there is a rule in the Kansas right to farm law that says you have to be in compliance with all state and federal law to be able to be deemed to be operating your farming operation in accordance with good farming practices, which is a requirement of the right to farm law to get the protections from being sued as a nuisance. And so they said, you can be sued as a nuisance. You were a nuisance. They successfully asserted that. You can't block it with the right to farm law. And basically he was wrong on every single point, to sum it up. A very long, tortured set of facts here, but he lost on every single point at the trial court.
And Roger, can you remind us of some of those rules really that go around the road ditch right-of-way?
Well, the case went on appeal, and that's where the courts really dug into the road ditch right-of-way issue. And at the Court of Appeals, a very detailed opinion, and we had known this was the case based on case law, but the Court of Appeals really elaborated on it. And they said that a road ditch right-of-way can't be used for private purposes without first getting adjacent landowners' permission or getting local or legislative authority, because that right-of-way is owned by the adjacent property owners. They are the fee owner of that road ditch right-of-way, and the public merely has an easement to use the roadway for travel, and that's it. But you own the subsurface to the midpoint of the road, is what the appellate court was saying. They said, just to give you a quote, they said, everything connected with the land over which the road is laid out, end quote, does not pass to the public. It stays with the owner of the underlying and adjacent land. So he couldn't lay his pipes in the road ditch right-of-way without their permission. That's a trespass. And because that was a trespass, then that prevents him from using the state right to farm law as a defensive tactic to prevent being sued successfully for nuisance.
Did this defendant try to use his operation of what he was supplying as a public purpose so that it was okay?
Yeah, and that's a key point here. You can use a road ditch right-of-way if there is a public benefit to it, a public purpose. So, for example, a telephone company can put a telephone wire in the road ditch right-of-way. They can bury a wire for that. A cable company can put a cable TV cable, bury that in the road ditch right-of-way. That's got a public purpose to it. His argument here was that the production of pork benefits consumers. And so there is a public benefit to that. The court didn't buy that at all. They said, no, you're putting this in here to get rid of that manure, which benefits you privately. There is no public purpose to that. So that was quite a stretch of an argument. I guess you have to give him a lollipop for a good try on that. But no, the court was pretty clear that you were doing this solely for your own private purpose to benefit your hog operation. There was no public benefit to that and no public purpose to it. Therefore, you have to have permission to be able to do this, and the county can't give you a permit anyway because they can't authorize you to do something in that ditch right-of-way that state law doesn't allow. And once it's determined that the adjacent landowners own the road ditch right-of-way, then that's up to the adjacent landowners to allow you to do that. The county has nothing to do with that. They can't allow that public easement to be expanded any more than state law allows it. And since there was no public purpose, the county had no role in it.
Roger made this all the way to the Kansas Supreme Court, and what did they say?
They affirmed the Court of Appeals on every single point. They determined that the plaintiffs did have standing to sue for trespass because they owned the fee interest to the road subsurface that he interfered with, and so that was the first thing that he challenged. They said, well, they can't sue because they don't have an interest. And the court said, well, yeah, they are the fee simple owners of the land that you violated without their permission. So yes, they are personally affected by this. They do have a standing to sue, and that you committed a trespass, is what they said in affirming the appellate court. And so when he buried the pipelines in the subsurface area of the county road, that's in the scope of the highway easement, which can only be used for a public purpose. And so without permission, he can't do that, and he didn't get permission to do that. And the court said, again, that the county has no authority to authorize any use of the highway easement that exceeded its scope and encumbered one of those adjacent landowners' private property rights. They also said he couldn't get summary judgment on their nuisance claim because the state right to farm law didn't apply because he was not in compliance with all state and federal laws and regulations by virtue of him committing a trespass. Now, what he tried to argue was, well, trespass is a common law provision. It's not part of statutory law, so therefore I am in compliance with all state law. And the court didn't buy that one either. The common law is part of the law of Kansas. Common law meaning judicial-made law. It's made by the courts. It's not statutory. But we have a lot of body of law in Kansas and in other states and in this country that's in the common law. And that's what the legislature meant when they said you have to be in compliance with all state and federal laws. And so that argument failed, too. So he lost on every single point, and the trial court decision was affirmed, and the jury at the trial court returned a verdict of $126,720 in property damages for the plaintiffs, plus $2,000 in nuisance damages, plus $50,000 of punitive damages. And so that jury verdict was upheld.
Roger, what does this mean for farmers?
Well, we do have a right to farm law, and that right to farm law is still quite valid. This case has nothing to do with wiping out any part of the right to farm law, and that says that if you're conducting your farming operation in conformance with all state and federal rules, you get a presumption that you're using best farming practices, best management practices, and if you were there before the person that's complaining about your operation, then you cannot be sued successfully for nuisance. You're not a nuisance. Somebody else moved to the area and started complaining about it, and there's even rules that allow you to expand the size of your operation, and still get the protection of the statute in certain circumstances. So that's correct, and it's also correct that you have to be in compliance with all of those laws, and the common law is part of Kansas law. And if you're committing a trespass like this, you can't hide behind the right to farm law to allow you to continue your operation. The other key point coming out of this is landowners, adjacent landowners to a road, own the ditch right away, and you have control over that, over somebody that wants to use it purely for their private purposes. So it's good opinion across the board upholding property rights of rural landowners.
Roger, I appreciate you taking the time to join us today and share with us some information on this case.
Thank you, Shelby.
That was K-State and Washburn law professor Roger McEowen. I will put a link in today's show notes on agtoday.net where you can read more on this blog article.